Chicago Mayor Brandon Johnson is going to be in front of the House Oversight Committee in Washington, D.C., and we are going to have coverage of that at the Center Square, so be sure to go check that out. But before then, you can go and read about the mayors of sanctuary cities testifying. Actually, I believe that testimony is probably going on right now. But you've got the mayors of New York, you've got the mayor of Boston, Chicago, and Denver that are going to be taking questions. All of this at the House Oversight Committee about sanctuary city policies and sanctuary state policies. So we'll review a lot of what was said tomorrow, but I've got in front of me the latest filings of the case that the Department of Justice brought against the state of Illinois, Cook County, and Chicago. Welcome in Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Let's go ahead and get right on into this and just a little overview of some of the arguments that are being made here. So if you recall, last month, Pam Bondi, the new U.S. Attorney General, sworn in, day one, files a lawsuit against the state of Illinois, Governor J.B. Pritzker, Cook County and Tony Preckwinkle, Chicago Mayor Brandon Johnson, and the Cook County Sheriff Tom Dart over the state's sanctuary policies for migrants. Two particular issues in particular are the Way Forward Act and the Trust Act. These pieces of legislation essentially say that state and local law enforcement cannot cooperate with federal immigration authorities enforcing immigration law. So the DOJ fighting, saying that the federal law supersedes Illinois law, and that the Trust Act and the Way Forward Act are unconstitutional. So that was filed last month in federal court. Well, yesterday was the deadline for the defendants in the case, the governor, Cook County President, Cook County Sheriff, and Chicago Mayor Brandon Johnson to respond. And we've got those responses in front of us now. We're not going to look at all of them, all right, because there's there's a lot, dozens and dozens of pages, but we'll do what we can to give you just an overview here. So this is the Department of Justice versus Illinois in a motion to dismiss that the state of Illinois filed, saying that the federal government filed a 3-count complaint against the state of Illinois and the governor. The complaint asked this court to invalidate 2 related Illinois laws, the Trust Act and the Way Forward Act, based on alleged preemption by federal immigration laws. That's count 1. Discrimination against the federal government, count 2, and unlawful regulation of federal government, count 3. The state goes on to say all the claims asserts against the state of Illinois and the governor fail as a matter of law and should be dismissed with prejudice. What with prejudice means is that if the judge does dismiss this, then the Department of Justice cannot bring this case in this form to the courts again, or bring that case against the governor again. So if it's dismissed with prejudice, then they can't bring the case back. I mean, they can always appeal that and go to the appeals court and ultimately go all the way to the U.S. Supreme Court if they wanted to. But if it's dismissed with prejudice, it means they can't bring that similar case back. If it's dismissed without prejudice, that just means it's not ready yet and you can bring it back later. But that's just what that means with prejudice. So moving forward here, both these Illinois statutes, the state says, effectuate Illinois' sovereign choice to opt out of using state and local law enforcement resources to assist with federal civil immigration enforcement. The 10th Amendment and the anti-commandeering rule derived from it protect Illinois' sovereign right to decline to provide this assistance, and no federal law cited in the complaint overrides the choice Illinois has made. So it goes on to also talk about counts 2 and 3, about the Trust Act and the Way Forward Act, and they say that the allegation is that the doctrine of intergovernmental immunity, which generally bars states from regulating the United States directly against the federal government or those with whom it deals. Both claims fail, the state says. The Seventh Circuit has already rejected the same essential arguments in prior challenges to specific provisions in the challenge to Illinois statutes, and that's some case law that they point to. And the same rationale requires dismissal of counts 2 and 3 in this case. It also goes on to talk about the independently, the claims against the governor should be dismissed as well. They argue that Illinois law authorizes the Attorney General, not the governor, to enforce the Trust Act and the Way Forward Act. Because the federal government has not shown that the governor could enforce these laws to its detriment, it lacks Article 3 standing to maintain a suit against the governor. All claims against the governor should be dismissed for lack of standing. So again, this is just the overview of the motion to dismiss that the state provided. And there's a much longer filing here, which goes into the case law and such. But I want to just review some of the overview here, right? Because these bullet points can kind of give you a better idea of what we're looking at here. So they give the background on the 2017 Trust Act, which actually passed and was signed by former Republican Governor Bruce Rauner, right? And ultimately that says that state and local law enforcement cannot cooperate with federal immigration authorities enforcing immigration law if it's just a civil detainer, but they can work if it's a criminal detainer or there's other criminal circumstances around that individual suspected illegal immigrant. The Way Forward Act in 2021 that Governor Pritzker signed ultimately says that ICE can't utilize state or local facilities. And so that ultimately meant some sheriffs that had open beds to allow for ICE to hold detainees there while they get them processed. That can't happen anymore. So it also goes on to make the arguments, and we heard some of this in that motion to dismiss. Federal law does not preempt the Illinois Trust Act. No federal law overrides Illinois' sovereign choice to opt out of federal immigration enforcement. No federal law requires Illinois law enforcement to provide the specific types of assistance plaintiffs now demand. Federal law does not compel Illinois to arrest, detain, continue to detain, or transfer custody of individuals for civil immigration enforcement. Federal law does not compel Illinois to affirmatively share release date information, particularly when it's routinely posted online, they say. So just because some sheriff's offices might post this stuff online, the state feels that they don't have to give it to the feds. Federal law does not compel Illinois to provide access to individuals in its custody for federal civil immigration enforcement. So again, that goes to the Way Forward Act and some of the arguments the state's making to try to go against this federal lawsuit the Department of Justice filed. The Trust Act is not preempted by U.S. law. The Trust Act permits the limited information sharing referenced in law. A broad interpretation of law would result in unconstitutional commandeering, they argue. The federal statute at issue have no preemptive effect because they do not regulate the conduct of private actors. And then they go on to talk about the Trust Act not violating intergovernmental immunity. So you've got that being the overview of the arguments that the state is making. But you also have the other plaintiff or the other defense in this. You've got Cook County President Tony Preckwinkle filing their own documents. You've also got Cook County Sheriff Tom Dart filing their own documents. But here you've got the Chicago mayor and Larry Snelling, the city's police superintendent. They say that this needs to be dismissed. Count one alleges that the WCO conflicts with various sections of the INA, the Welcoming City Ordinance in Chicago, and you've got the immigration law that they're ultimately saying it's all hunky-dory. As to conflict preemption, plaintiffs argue that the WCO conflicts with the INA because the WCO prevents CPD from assisting with ICE seeks to detain alien or for civil immigration violations. But there's no conflict here, as the INA's terms make clear the local participation of civil immigration enforcement is voluntary. So again, you got these really dense legal arguments that are going to be made in court, but just an overview again of some of what the arguments are. A lot of interesting things are going to be said and filed in all of this. So now we have the next step. You've got responses that are going to be made by the DOJ, and we'll be watching that closely. Obviously, this all happening yesterday when they filed these papers in the federal courts as Brandon Johnson prepares to go in front of the U.S. House Oversight Committee to testify about the migrant sanctuary policies. So here we are with more Illinois in Focus. It's right here each and every weekday morning. Wake up with us at thecentersquare.com. Get the headlines at the Center Square, and also like, subscribe, and follow along here on YouTube for clips and segments and so on. And if you can't make the live show, you can always check out the Center Square and Illinois in Focus where you get podcasts. All right. We'll see you on the other side.